Hi, friends. Hello, hello. We're going to have our live today with me, Alina Shaltsova, immigration attorney from New York. We're going to be discussing the recent memo from immigration courts with regard to how immigration judges are going to address certain cases. And this is a very important update for those of you who are waiting for your first hearings in court after receiving notice to appear. So thank you very much for joining. Thank you very much for liking and sharing the stream. I hope you're going to do that if you find it helpful. And of course, as always, please send your stars, send your hearts if you're watching me on TikTok. And most importantly, please, in our chat, send your questions so that after I give you my update, I will be able to read them and help you out by answering those questions. And we can discuss whatever you want, absolutely, if we have time. And I usually answer most of you guys' questions. And if I don't, for some reason, because I'm running out of time, don't be upset with me. Just please connect the next time I'm live, and I will be very happy to help you guys out. And if you need a personal consultation, something you want to discuss in person, something you would like to discuss confidentially, please reach out to my office. Our office number is 917-885-2261. You can see it at the bottom of the screen if you're watching me on Facebook or if you're watching me on YouTube, or visit our website, shaltsova.com. So thank you very much, all of you, for joining. Thank you guys on TikTok for sending the hearts. And let's start. So what I wanted to share with you is a very important thing, and I'm going to explain why it is important. It is important for those of you who are waiting for your day in court. Some of you entered the United States using parole method at the border. Some of you came to the United States through CBP One app and also were paroled. Perhaps you ended up in removal proceedings differently. Or maybe what happened was that you filed for a green card or citizenship, it was not granted, and instead you received notice to appear. But in some cases, when notice to appear, Form I-862 is issued, and you would have that date and time of the hearing at the bottom of the notice to appear. The hearing actually does not take place. It doesn't take place. You are waiting and waiting for the court, and you maybe even call the court, and in response, you would find out that your case is not filed with the court and you just need to wait for the update. And what happens is that you may get stuck in this limbo situation for months and sometimes even years. So in response to this particular messy situation, immigration courts decided to fight it their way. And their way is going to be a way to push the prosecutors to do their job and to file this notice to appear with the court within certain time frame after they give you the notice to appear, so that the case is moving faster, the case is moving through the court system more efficient. But if the prosecutors do not comply with the court set deadlines, the case is going to be marked as FTP, failure to prosecute. And sufficiently, you guys, those who are waiting for that day in court, are going to lose your day in court, which you're not getting it anyways. And sometimes it's a good thing, because then you know that you can, deal with your immigration issues through affirmative process, be it you file adjustment of status, not with the court, but with USCIS, or you file your asylum claim with USCIS. But for some of you, it's going to be a less desirable outcome. Some cases are preferred to be heard in court rather than before USCIS, due to judges having deeper expertise in certain asylum issues due to judges having certain flexibility. USCIS is extremely inflexible, as we all know that. So you need to know that there is this policy, and you, if you don't have an attorney, will have to check whether or not DHS complied with their deadlines and filing obligations timely. And if not, you will have to start reaching out to the prosecutors or your attorney, pushing them to comply. On my screen on YouTube and Facebook, you can see a copy of that memo from EOIR that explains the deadlines. I can read them to you, but I'm sure that you can find this information in open sources as well. Basically, what's happening is that for any non-detained cases in which DHS does not file the NTA with the immigration court within 120 calendar days after scheduling the case, EOIR will classify the case as failure to prosecute. 4 months they give them. Also, for the cases that already been in the system, what's happening here is that if the hearing is scheduled between the effective date of this memorandum and December 31st, 2025, the NTA must be filed by close of business on March 31st, 2025. And if the hearing is scheduled on or after January 1st, 2026, the NTA must be filed by June 30th, 2025. Otherwise, the case is out of the court, out of the system. Similar situations happening in criminal courts. It's been going on for years. Sometimes a defendant in a criminal case may not face the court because the prosecutor didn't do their job fast enough. So we see that similar attitude, similar approach is being implemented in immigration courts. I do not know how long it's going to last and what the prosecutors are going to do in response. We know that the courts are overwhelmed, 3 million cases. I'm sure the prosecutors are overwhelmed as well. So the whole situation is messy. It means that you, as a person who doesn't have an attorney, if you don't have an attorney, you will have to be the organized one and organize everybody if you would like for that case of yours to be heard in court specifically. But it's a very important change. You need to know that, and you need to be prepared for that. And now, guys, if you have questions, I'll be very happy to answer them. Let me start with my TikTok followers and those who are watching me on YouTube and Facebook. Please don't be shy. Don't be shy. Ask your questions. Say hello. Let me know where you're watching from. Let me see. I have tons of people on TikTok. Hello, hello. Hi, Michael. Hi, Ricky. Hi, Tarn. Hi, Mehmet. Hi, Leonardo. Johnson. CRT Collector. Yes, yes, yes. Hello, hello, guys. Let me know if you have immigration questions. I help with United States immigration law, not Canadian one. Hi, King Saudi. My probation ended in 2021. When can I file for N400? I'm not sure if you can file for N400. It depends on your conviction, because what happens is that if you're convicted of certain crimes, you may be forever disqualified from becoming a citizen in the United States. So just because you served your probation, it doesn't mean that you qualified for citizenship and for that good moral character. I do not know your situation. What you need to do is you need to obtain certain documents related to a criminal case, such as certificate of disposition, minutes of guilty plea, and minutes of sentencing, and show them to an experienced immigration attorney who will be able to advise you whether or not that conviction had any effect on your green card and when, if ever, you can file for citizenship. It's very important to do that. Don't miss that step. Hi, Muhammad. Can you guide me, please? How can I apply for US or Canada, please? I guess you would like to know how you can move to the United States or Canada. Again, I'm not qualified to give any advice as to what's happening in regards to Canadian immigration. But generally speaking, if you're seeking to come to the United States, you either will have to have a certain family member who's going to sponsor you, find a job, an employer, have a pretty high qualification yourself, so that you can qualify for EB1 or EB2 national interest waiver, immigration visa, or you are an investor and you have significant amount of money, starting with at least $100,000 if we talk about non-immigrant investment route. Or you can be lucky and win a DV lottery. Hey, a lot of people do. Let's see if we have more questions here. Thank you very much, guys, for your gifts. Those who are watching on TikTok, for the roses and stars and hearts. Thank you very much. How long does a motion to reopen take? Eyes on Gambia is asking. It depends on the court, and it depends where you filed it, with Board of Immigration Appeals or with immigration court. So if you filed it with immigration court, typically you're going to see a result within 30 to 90 days. That's a typical time frame. Thank you very much, guys, for the roses. And if you file with the Board of Immigration Appeals, it may take up to a year to receive the result. Board of Immigration Appeals is much, much slower, just so you know that. Does Germany and US exchange information about immigration? If they do, it's not going to be public, but I'm pretty sure that yes, they do. Now, what information you are concerned of? Tell me. If you tried to file for a US visa and it didn't work out, and now you would like to file for a German visa, most likely whatever happened in that consulate is not going to be important. But if you filed for asylum in the United States and now you try to conceal this fact and you are filing for asylum in Germany, Germany most likely will know about that. It is a violation of your privacy, but I've seen that happened. So I know for a fact that something is going on, and Department of State, unfortunately, or whoever is there, is sharing that information with other consulates and governments. Hi, Dane, Anthony. Been out of status for a while, but my WAC status is still pending. Withholding of removal. I'm not sure what that means. So if you give me some more details, maybe I'll be able to answer your question better. Is there any news for a U visa? Not really. We are starting to receive a lot of those bona fide determinations for those of you guys who have U visa pending. So that's a good sign. And some of my clients already received even the work permits based on U visa pending, but that's about it. I don't know of any new law that would speed up the U visa backlog, unfortunately. Let me take some questions from our YouTubers. Hi, Ahmad. Hi, Jazz. How long does it take for a motion to reopen old removal order based on I-130 in California? It really depends on the judge. If you have a strong motion to reopen and the judge is a good one, no more than 30 days, you should have your result. Hi, Isha. If someone is trying to adjust I-45 through 245I, would apply for PIP affect the case? Case has been sitting in field office since 2023. I-130 was approved since 2019. No, PIP is a separate application right now. You know that. Unfortunately, the approvals are on hold due to the federal litigation. But what happens is that if your parole in place is granted, you no longer need to use 245I. Okay, so what you can do, you can file a new application for adjustment of status 245I and try to substitute it, try to amend it rather. So not to lose your filing fee, I think you can try to amend it if it's still pending. That's how I would try to do it if your PIP is granted. All right. So the big difference is that you will you will not need to go through qualifications for 245I, showing that you were a principal or derivative beneficiary of a certain labor certification or immigrant petition filed prior to a certain date. Hi, 11T. Hello, can I apply for a writ of Mandamus? I'm waiting for my asylum interview for 3 years. You can, but most likely you're going to lose. There was a recent case on somebody concerning someone who filed that writ of Mandamus after they were waiting for 4 years for the asylum interview and they got denied. Federal court decided that it's not long enough of a wait considering the current circumstances. So just keep that in mind before you're going to be spending tons of money on that lawsuit. Okay. I would suggest try to expedite and wait a little bit longer. All right. Hi, Tom. I got an individual hearing date in immigration court, but now court asked me to take the case off calendar. If I agree, can I move to another state and move the case to another court? If the case will be off the calendar, it means that if you would like to move the case, yes, you can. You may have to have a motion to recalendar the case first, so it's active. However, you in this situation may object. What happens is that the court offers to take the case off the calendar, but you, as the individual who's going to be affected by the decision, have a right to object. So if you have a strong objection as to why you do not want to be in this limbo situation, then you can try. Now, if you're somebody who also qualifies for TPS status, you may have a challenging time convincing the court that you should be provided a day in court when you are no longer removable because you have TPS. Something to keep in mind. Thank you very much, guys, for the roses on TikTok. Let me see. We have more questions here. Hi, Noble MP. Can I withdraw my marriage I-45 that I filed with parole under Section 212D5A issued by ICE at the border and refile anew with a military PIP I-94? I mean, sure, you can do that, but why would you want to do that? Explain to me, please, what's happening in your case that you're trying to do that. Unless you already have that other military parole, why would you want to withdraw your I-45? I believe that everybody agrees that if you have 212D5A parole, you should be adjustable, okay? So I don't think it should be an issue unless there is something else going on. I just don't see a benefit for you to go through military parole in place and wait longer. Hi, Chem. I have I-797 notice of action. It says currency copy available. Can I fly to Canada from third country or I need the original notice? I do not know what was approved for you. I-797 is just a standard format for any notification that USCIS is issuing. So I have no idea as to what benefit was approved. Hence, I will never recommend you leaving the United States unless we know that you can return. Okay, this is very important to know. All right. Let me see if we have more questions. No problem, Artem. Thank you very much. So let's see, my dear TikTok followers, thank you very much for your hearts. I know that it's a very exciting Saturday afternoon, Saturday evening, and we are all here dealing with immigration issues. Hi, ma'am. Malik, I applied for green card since 2-5 years. Haven't, 2.5 years probably. Haven't received it. Can you help? Maybe it depends on what was the ground for your green card, whether or not you were called for the interview, right? And what in general is happening with regard to immigration status. Sometimes, guys, and I'm not saying that this is your situation, sometimes I see that people are filing for the green cards when they don't really qualify for them. They miss some important qualification, and they file for those green cards under this impressions that they will get the green cards, and then there is this horrible disappointment. I hope you worked with an attorney and they did the right thing, and it's a good lawyer, good practitioner. 2.5 years sounds a little bit long, but not for example, VAWA cases, okay? So if it was a VAWA case, I'm not really surprised that it's taking a little bit longer. Thank you very much, guys, for your gifts. Let me see. Hi, Ash FCB. I-45 approved, and today it said card is produced. When will I receive it? Such a big moment in your life. Congratulations, guys. It's amazing. Thank you, Wendy, for these coins. Such a huge moment. It means that within the next week, maximum 2, you should receive, thank you guys very much for those fluffy hearts, they're very cute. You should receive your green card. It's extremely important. What you're going to do when you're going to receive your green card, you're going to take a copy of it and you're going to store it, store those copies. I usually advise clients to email copies of important documents to themselves, so you always have access to them. Also, you're going to update your ID. You're going to get now state ID that is this verified and good for travel when the Real ID Act kicks in. Don't forget to update the Social Security office just in case, even though they should receive automatic update that you are a green card holder, all right? But I'm sure everything will be fantastic. Thank you very much, Mike, for this interesting gifts, very interesting fluffy hearts and different signs, very cute. Thank you, guys. Hi, Double Chief. Does USCIS waive adjustment of status after 1 year of IG asylum grant? Oh, no. USCIS is not going to waive, important step. They're not going to give you green card automatically, guys. You will have to file, pay the fees. Just to make sure that you check the correct fees and everything. You will have to file for that adjustment with USCIS. You don't have to wait for the entire year to pass from the time that the judge issued the approval. You can actually pre-file your green card application earlier, maybe even 6 months earlier, all right? But what happens here is that you have to show you've been physically present in the United States for at least 1 year at the time when USCIS is adjudicating or making decision on that application for you. Hi, Dan. Technically being out of status, but I'm working, paying taxes. All right. Let me know what your question relates to. If somebody filed for you something like I-130, but you never filed I-45, I-130 by itself does not give you any status. It's very important to know that. Same situation with I-140. Some people have this mistaken impression that when an employer starts the process for that person's immigrant visa or green card, the beneficiary person is going to get some sort of a status right away. This is not the case. So please consult with a good attorney prior to investing thousands and tens of thousands of dollars. If you overstayed in the United States and someone is offering you an employment route. I see tons of cases every month where people are scammed, basically. They promised that they're going to get a green card in the United States without leaving the United States because some sort of a company is going to sponsor them, even though the person overstayed their visa. It may happen, but it happens in a very narrow situations, in a very small amount of cases, okay? Hi, Rico. Do you handle asylum court representation? Absolutely. We have very strong, very high percent of approval of asylum in court. I love asylum cases in court. I do help people in all 50 states, so please don't hesitate to reach out. It's 917-885-2261. We'll be very happy to help you guys out. Is it safe to travel international with I-751 extension? Absolutely. Unless you're going to, God forbid you will, commit some sort of a offense, you should be absolutely safe coming back to the United States after travel abroad if you have I-751 extension. Okay? All right. Thank you, guys. All right, let me see if you have more questions. Do you think parole in place will survive? And do you think the stay will be lifted October 10? I think parole in place will survive. Why? Because we did have similar situations already. Humanitarian parole was challenged and it survived. And I think parole in place will survive. Of course, you never know with specifically conservative judges, but the government also has strategies to address the situation if they really want to. If you recall, what was happening in some cases in the past is that cases were filed simultaneously in various federal courts. Some courts were friendly, some not, and eventually the decisions that have nationwide effect would cancel each other out and would bring the result that we need. So that's one of the strategies. But even without that, I believe that parole in place will survive. How long does it take to get a work permit based on marriage? If everything goes well and you are qualified for adjustment of status, it should take you only about 3 months. Okay? Yes, thank you very much. Heart puff. Yes, that's exactly what it was. It was a puffy heart. It was very cute. And roses. Thank you. Hi, Hashim. Mind your business. How long does one have to wait to file for a spouse when they get married? You don't have to wait at all. You can file that I-130 after you get married the next day. But you need to see if you have enough evidence. Because when you file that case for your spouse, you want to make sure you have a good, very well prepared filing so that the government is going to issue approval fast instead of sending you requests for more evidence or endless interviews. Just keep that in mind, okay? Very important. Hello, I have a brother illegal in South Africa. My dad is a US citizen. Can I help him with the green card? All right. Is your brother in South Africa or is your brother illegally in the United States? Not really sure. Now, the father, who is a US citizen, may file a petition for an adult, married or unmarried child, but it takes anywhere from 10 to 14, 16 years before that unmarried child or married child can use the petition. And if that person is in the United States, currently, they will have to demonstrate that they've been in lawful non-immigrant status throughout their stay in the United States. Now, if the person in the third country, in South Africa, and he's from Algeria, and sure, they will just, remain in that third country. It's not a problem for United States immigration, but it takes a long time. So once that 10 years something pass, the person is going to go for an immigrant visa. Typically, an immigrant visa interview is scheduled in their home country, in the home country of the beneficiary. Typically, the United States does not care if the beneficiary lived illegally in some third country, violating the laws of that country. That's not important, unless the violation of the laws of that country also was a crime of some sort, okay? But usually it doesn't matter if the beneficiary resides illegally in a third country and a family member would like to sponsor them. What matters here is the time. It may take a very long time before certain family members will be able to benefit from those I-130s, okay? All right. That's interesting. I don't have I-94, the parole issued by ICE at the border, but I have the military PIP. Sure, then listen, file that case, amend the filing, try to see what can be done. From what I understand, you shouldn't have filed your I-45 if you didn't have proof of your parole. If you did, I'm not sure why you did that, but what you can also do, trying to save that filing fee, is to supplement your documents. What happens is that if USCIS is going to be considering your case and they see that there is no proof of parole, they're going to ask you for that proof, all right? They're going to issue requests for more evidence in 99% of the cases. And then you will have your opportunity to provide the evidence that you have. Perhaps, maybe it's not your case, because I do not know the timeline of what's happening, but it should work. Hi, Old Wolf. I have asylum case open with a judge after I've been sent from the officer. Typical situation, you've been referred to immigration court after affirmative asylum interview. What's your question? Hi, Umir. I need help regarding my father. He's in USA from 35 years, and in case of E81 family case, denial in 09. All right. I would not be able to fix your father's situation over this little conversation here. What I think you need to do, what anyone with extensive immigration history has to do, the father has to obtain a full copy of the immigration file first, and then present it to a good immigration lawyer for a review, especially if there was a denial in the past, to see how to address it. We recently had a case, also a father of a US citizen being sponsored. The father had, in the past, many convictions, criminal convictions, and for that reason, previous application for adjustment of status for the person was denied. But then we were able to address this particular issue with USCIS by fixing those convictions. They either were sealed, expunged, or we were able to show that they were not important for immigration. And when we were like third lawyers for that person, but when we got the case and we did this excellent job and we advocated for the client during the interview, finally the person received their green card. So my point is that sometimes, not always, but sometimes, often, those stale immigration cases, cases that are hard to win, cases with previous denials, can be won with a refiling, provided that we can effectively address the issue that previously prevented a person from being granted. Okay? Very important to understand that. Not every case that has been denied in the past is hopeless. Hi, Black, don't crack. All right, that's the nickname. Will you take a case which is in 221G for over 1 year? Embassy not replying to inquiries? Absolutely. Of course. There are a couple of ways you can address such cases. You can file a legal net inquiry. You can file a lawsuit. All right, but we also need to know there are potential dangers as to why the case is not being granted. We usually screen the client. We go over the questions that the consular officer asked them at the interview, what documents were requested, to see what potential dangers may be found and why the case may not be granted. Not just stuck in administrative processing, but if the case can also result in a denial. It's very important to understand this prior to pushing the embassy to make the decision. Hi, BLD, how long the procedure takes for my mother who came with a tourist visa? We apply for the green card. Parent sponsorship, provided that the USCIS is not going to accuse your mom of violating any immigration laws, that regulations that would prevent her from getting a green card, like, for example, immigration fraud. Parent case should not take more than 6 to 9 months, okay? Hi, Wendy Mike, removal proceedings were terminated by the IG 8 years ago, but the case wasn't granted. What's next? So the case was just terminated. It means you're no longer in removal proceedings and you need to find a new way to get your green card, we need to see how you may potentially qualify for the green card based on marriage, based on sponsorship of some sort with a waiver. If you are eligible, can you file for a U visa? Have you ever been a victim of a crime? We usually need to know everything that happened to you in the United States to see if there is any hope. Sometimes you can find a solution for people who are abused by their employers. U visa, T visa cases, guys. Sometimes you can benefit from being an indirect victim of a crime. It's rare, but it's possible in certain cases. But most people will need a family member usually to sponsor them, okay, if they overstayed their visa for a very long time. That's how it works. Hi, Umer. He's old, 70 years old. His lawyer didn't do it in good way. Okay, I'm sorry to hear that. Right, so all I can tell you is that we will need your dad's case, his file, to review it. And then after the review, we're going to recommend as to what he can or cannot do. Because you have to be very careful with immigration cases. It's almost like a doctor. My goal is to improve your life, not to make it worse, okay? Hi, Mom, to Georgie. Litigation against my mom from her sponsor. Can this affect her visa? Does she need to tell them? Against your mom from the sponsor? The sponsor is suing your mom? Well, that's not good. I'm not sure what's happening. Why your mom doesn't want to settle the case? What's going on? And who was that sponsor? What are they suing her for? I mean, I wouldn't advise anybody to share with the government anything that may potentially hurt them, right? It just goes against common sense. But I would advise that your mom speaks with an attorney, all right, to see how she could protect her status and her rights. Very important. All right. Hi, Alia. Can you please check your inbox? All right. So my TikTok inbox is completely overlooked and completely full of messages. Why I do appreciate all of you guys' messages because there are so many of them. Sometimes I cannot get back to all of you timely, but it's very easy to get my full attention when you book a consultation. You book a consultation on my website. It is working 24/7, shoutsoa.com, and we can absolutely go over your case. Now, if you are not in a position to pay for the full consultation with an attorney, we do offer paid time also, with the immigration intake specialist, where you can share your story and then they bring it to me and I quickly go over what happened and we give you roadmap as to what we believe can be done in your case. Okay. All right. I'm getting I-45 interview, but I-601 still not approved. Is it possible I will still get a green card? Yes, of course, because if you have to have I-601 waiver approved, usually the officer will be asking questions about that application waiver at the time of your I-45 interview. Okay, that's how it works. All right, if we have more questions, let me see. We do have a lot of questions, and I am running out of time. I have a case with a judge. All right, I think I answered that one. Yes. I got withholding. Hi, Fatu. I got withholding of removal. How can I travel? You can't, guys. Unfortunately, withholding of removal means there is a removal order against you, but the judge also issued an order stopping physical removal against you. So, unfortunately, somebody in the status of withholding of removal cannot travel. You will have to reopen your case and file for another status if you can, if you really, really desire to travel. That's how it works. Sometimes your situation changes. You may qualify for VAW benefits, so I-130 benefits, or you may even sometimes file for asylum. Guess what? Many people from Bangladesh, and this country just been on my mind for a while recently because I've seen so much disturbing footage information from Bangladesh. So the point is that many people from countries where there is a recent power shift may qualify for an exception from 1 year filing deadline for asylum because of the changed country conditions. If you have already an order of removal against you, you can file that motion to reopen based on changed country conditions if you believe that removal will result in harm to you, right? So I mentioned Bangladesh, but I'm sure there are other countries in the world that went through huge changes within 6 to 8 months, because that's usually the time frame that the government gives you to file that motion to reopen or exercise your right to an exception to 1 year filing deadline from the time of the changed country conditions, right? So maybe that tip is going to help you to finally fix your status and get yourself on the right track. All right, let me see. Hi, boss. Would food stamps or getting a temporary ban for it for 12 months affect citizenship? I'm not sure what's happening here. What you need to know is this. Typically, certain benefits that you receive are not going to directly affect your citizenship. But if to qualify for those benefits you provided incorrect information, then it may affect your citizenship in finding of unlawful commission of unlawful act. So in my 16-year-old practice, I encountered some cases where people were denied citizenship, even though they didn't have criminal conviction. But because USCIS didn't like certain things that they've done, they call it unlawful acts. Okay. Also, if you did not file your taxes while being a green card holder, if you owe money on your taxes and don't have a payment plan as a green card holder who's filing for citizenship, this may disqualify you from citizenship. But getting Medicaid and food stamps by itself, not necessarily. We need also to know how you got your green card, and if you put correct information on your application for those benefits. All right, this is very, very important. Not everybody who is a green card holder is subject to public charge rule. You need to know that. So depending on your situation, this food stamp situation may or may not affect you. Well, guys, thank you very much for watching. Thank you very much for your hearts and likes and shares and asking questions. We had a really great time today. I hope that you're going to sign up for my channels, TikTok, YouTube, or Facebook. And I hope that soon we're going to meet again. Hopefully next Tuesday night, we're going to be here. Don't forget to join. And I'm going to share with you the most interesting recent immigration news and provide my tips. And we're going to discuss your questions again soon. Thank you very much and have the best weekend.